Well, today we are here to discuss about the WHSA, which stands for Workplace Health and Safety Act. I'm here along with Shivanshu to present our ideas about the same act, which applies not only to the province of the Manitoba but also to the like all the provinces which lies in Canada. The first thing about this act is like it is a piece of legislation first of all, and is designed to protect the workers' health and safety while they are on the job. Somehow the registered nurse act also helps in this case, as a registered nurse with specific knowledge is responsible for taking care of all the employees who work in an organization. The chief occupational medical officer's authorization granted to the OHN are further clarified in the section 17.3 of WSHA. And then there are some purposes that this act plays a vital role in. Its main objective and the main purpose is to protect the employees and the self-employed people from the risk to their safety, health, welfare arising out of or related to the activities at their placement of employment, and to protect other employees from the risk to their safety and health arising out of or related to the activities at the places of the employment. Specific goals and objective. Without limiting the generality of the subsection, the objective and the purposes of that this act includes promoting and maintaining the highest level of the physical, mental, and the social well-being of the workers, preventing illness among the workers brought on by their working conditions, protecting the workers while they are employed from factors that promote illness. Some other purposes of the act are the placement and the maintenance of the workers in the job that promotes their physical, mental, and the social well-being, maintaining employees in a working environment that is suitable for their physical and the psychological conditions as well, promoting the employees' rights to be informed of the safety, health risk at the place of the employment, and take part in the safety and health activities at their places of employment, and also to decline the risky work or work without fear of retaliation.
So the jurisdictions of the Act, the Crown in right of Manitoba and every government agency. Every employer, employee, and self-employed person whose workplace safety, health, and welfare standards are typically under the exclusive purview of the legislature of regulate, and any other person whose workplace safety, health, and welfare standards are typically under the purview of the Crown, the right of Canada, and every government agencies which work under this Act.
So there are lots of duties that the employers have to, or sorry, employees have to perform, which are actually the human resource of the company. So the first thing that they have to follow is the laws and the regulations when they are working over there, and they have to use a personal protective equipment and then dress appropriately as instructed by their workplace. And also they have to inform the employer and supervisor of any risk at the work, and use a proper safety gear and work safely as directed by the employer. Any missing or broken equipment which is protective one, or the gadget that is protective one, should be reported to the employer or the supervisor. They must have obviously their fundamental rights, and that the first is a right to reject the dangerous work, possession of the right to engage in health safety activities at work through the health safety committee or as a worker representative, and right to knowledge, right to information regarding present and possible risk at work. Then there are some duties that falls for the manager and the supervisor, and the duties are as follow. First is to ensure the employees adhere to the laws and the regulations while at work. Second is the supervisor have to see that the employees are using the recommended protective gear and or devices, or they also have to look for to inform the employees of the potential and actual risk that they have to go through, and provide the written instruction to the employees outlining the steps that should be taken to protect them, and do all the efforts that is practical under the circumstances to protect the employees. And last, when the managers and the supervisors carry out the actions on the behalf of the employers, they are accountable for carrying out the acts requirement for the work they supervise.
So there are some duties of the employer as well. Company owner must create and maintain a committee for health and safety, or let employees choose at least one representative. Make sure the workplace is secure by taking all conceivable precautions. Employees should get training on potential risk, how to use, handle, store, and dispose the dangerous materials safely, as well as how to handle the crises which are getting in the company. Ensure the employees understand how to use and handle the equipment safely. Ensure the employees are using any personal protective equipment that is required. Report any critical injuries right once to the government agencies in charge of OH&S. Choose a capable manager who will establish performance expectations and guarantee that safe working conditions are always upheld.
Now, after knowing the uh, all the rudimentary things about the act, like knowing the purpose, knowing the jurisdiction, and knowing the duties of the different human resources, we are coming to the point of interpretation through a case study. And this case was between the appellant and the director. Here, the appellant is ETT Babu Homes Limited, and the other party is the Director Workplace Safety and the Health, and it is before K. Pelletier, the vice chairperson. So the relevant facts about the same are like appellant has filed an appeal on July 27, 2018 in relation to the section 53.1 to the WSHA, which was related to the decision of the director mentioned before, who issued an administrative penalty of $2,500. Accordingly, the section 53.1 clause 2 of the same act, and the appellant had been issued improvement orders before which he failed to comply with the section 14.3, which was regarding the health and the safety, the arrangement of the guardrail system. These orders were repeated 3 times in the span of the 2 months, um, which appellant neglected. In fact, he did not make a request for the improvement orders to the MLB or the director. The appellant and the director attorney appeared before the board at the hearing that the board held on September 20th, 2018. The appellant provided the arguments and the supporting data. Despite not calling any witnesses, the director's attorney did submit some arguments in relation to the appeal. No one contested the appellant had followed the improvement orders during the hearing. Now, it comes the facts and the defense, which actually was in the case. For failing to use a guardrail system, as mentioned before, the appellant was fined $2,500 administratively by the director. The appellant argued that he did not anticipate it, or he did not anticipate facing an administrative fine from the director when he complied with the improvement order. But actuality was different. He was not informed that even if he complied to the improvement order, he might still receive the administrative penalty either in the improvement order or in his conversations with the representative from the workplace safety and health. According to the appellant, the fine is not significant and will be difficult on his small family business. So, in response to that, the director's attorney claims that appellant conceive an administrative penalty as a result of the breaking an prescribed WSHA provision. And because the director was convinced that the appellant's non-compliance posed a serious risk of injuries to its employees, the director cited the board's decision in Master Roofing Limited is in the support of its position, and the director workplace safety of health. Case number 25814 WSH.
The improvement order mentioned in the notice of administrative penalty that is the subject of this appeal was not hailed by the appellant. As he was already mentioned, the appellant did point out that if he had known that an administrative penalty could be imposed even if the order was followed, he would have undoubtedly appealed the decision to make sure that his rights was upheld.
And then the board requested the parties' positions in the letter to them um, after hearing regarding the director's decision to impose an administrative fine in these circumstances and regarding the interpretation of the application of 53.1, as I mentioned before. The appellant replied that he had nothing further to say than what he had already stated during the hearing. And then the director attorney responded that 53.1 of the WSHA, unlike other clauses under the section 53.1 clause 2, does not require prior orders to have been issued, and can therefore be issued for the first time violation itself. It's not that director had to give the orders before giving the penalty. So in addition, the attorney pointed out that when deciding whether an administrative penalty is suitable and the consistent with, last point, the director is permitted to take the safety and the health officer's recommendation into account under 53.1. The council also clarified that in general, the director conducts a technical review of the file to decide whether to exercise their discretion and impose an administrative penalty based on the information reviewed.
In this instance, the director's attorney stated that the director relied on the improvement orders and the data provided by the safety and health officers in coming to the conclusions that the appellant had violated a specified provision of the regulations and the violation involved serious risk of imminent physical harm to the workers. The director took into account the appellant's prior improvement orders, which were all of the similar nature, because they all involved work being done at heights without the proper fall protections or guardrail systems. When exercising her discretions and imposing the administrative penalty, these orders, which were issued to the appellant 6 times between June 23, 2017 and June 11, 2018, were also taken into considerations by the director. The lawyer stated the number of improvement orders issued to this employer were demonstrably ineffective in securing outgoing compliance with the law.
Yeah. In his reply, the director's attorney also included a section on the board's authority in appeals. In light of the section 53.1 clause 9 of the WSHA, council claimed that the board lacked the authority to consider the merits or the legality of an improvement order under this heading. The council argued that board's approach to an administrative penalty issued in accordance with 53.1 clause 2 a second point should not differ from the board's approach to an administrative penalty issued in accordance with any other provision of that section. In other words, the board should stick to this stance that it has limited jurisdiction when considering an appeal of an administrative penalty, and that is it is not in its job to judge the merits and the reasonableness of the improvement order. According to the section 53.1 ninth clause of the WSHA, the board's only power is to confirm and reverse the administrative penalty. Only in cases where the improvement orders itself is appealed first does the board have the authority to modify an order. The appellant was given a chance to comment after the board received the director's reply, but no reply was received.
The appellant of ETT Babu Homes Limited is hereby dismissed by the Manitoba Labor Board, which is the decision of the judges, which was submitted to the Manitoba Labor Board on July 27, 2018, and the administrative
मैं
penalty
दोबारा तो
of
इन्हों एडिट कर दूंगा. तू 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 स्टार्टिंग च क्या बोला? एपिलेंट बोला है. एपिलेंट नहीं है, अपील है. अपील ऑफ.
okay,
दोबारा तो बोले लाइक नाउ कम्स द डिसीजन ऑफ द जजेस एट
okay,
बोले तो
okay.
बोले.
So here comes the decision of the judges. The appeal of ETT Babu Homes Limited is hereby dismissed by the Manitoba Labour Board, which was submitted to the Manitoba Labour Board on July 27th, 2018, and the administrative fine of $2,500 is hereby confirmed by the judges. So here we come on the conclusion which are made by the judges in this act. It is thus of great importance and priority to revise that this legislation provides the security to the employees and other human resources from all other corners of health and safety parameters when they are prone to the negligent attitude of some folks as mentioned in the case discussed and hence. These cases get resolved with the sections of such seriousness such as 53.1, 53.9, and 14.3, which safeguards the working employees from any kind of insecurity at the workplace, ending in the fine to the culprit as in the case mentioned above with $2,500.
The case and the legislations are both important for human resources since knowing the rights of the safety may result in a better performance and more freedom and security. Moreover, the risk for not complying with the act involves in getting serious fines and the legal issues. We are certain, as far as our practice is concerned, that we would follow all the guidelines of the law by making sure that there is the availability of every source of safety and security at the workplace, as well as by organizing awareness programs at the workplace about this powerful law. Thank you very much.